So I'm going to make my 3 points now. First, I would be remiss not to start out by showing that where I agree with John Samuels. The pressure for inversions is not going to go away as a result of shifting to a territorial or dividend exemption system under any version that has been proposed by the United States to date, or that I think plausibly could be adopted. The experience of the United Kingdom, I think, has shown that robust control of foreign company rules triggered corporate expatriations. And the reason I say that is because prior to that time, they were able to use their foreign earnings with the upstream loans that Michael referred to. So their driver wasn't what seems to be the driver here, which is so-called trapped offshore earnings. Their driver, in terms of expatriations, had much more to do with CFC rules, and all of the proposals in the US are increasing the strength of one form of CFC rule or another. So that's my point of agreement. My second, and I think possibly most important point, is that the taxation of multinational business income raises important issues of economic justice. Word has not been used today. But that concept, I think, was put squarely on the table by the President's State of the Union speech. And I don't think there has been a reset in the thinking. The framework for business tax reform was put out in early 2013. It seems clear to me that after that speech, a lot of things have changed, and I haven't seen it filter back into the rest of the administration's proposals. Economic justice requires that the owners of capital pay their share of the overall tax that allocates the burden on an ability to pay basis. As I had my two co-authors, Cliff Fleming and Bob Peroni, observed in a 2001 Florida Tax Review article, it is unfair to the rest of us to give an unjustified special tax break for foreign corporate income. One of the issues we're here on, is it unjustified? That's a reform issue. Or is it justified? And that's the source of the research that needs to be done that John was referring to. But that is most troubling, that it seems to me economic is most troubling, justice is most clearly on the table when we take income that was earned under the privilege of deferral, that income was earned under the privilege of deferral. And if we allow that income to be taxed at a lower rate or to be exempted, that seems to me to raise fundamental economic justice issues if you're going to have to increase tax somewhere else. So where does all that point me? Where does that take me? And this is my third set of points. As we learned from an earlier panel, inversions seek to exploit the line determining when a corporation is a US corporation or when it's a foreign corporation. It's an attempt to gain the advantage of being a foreign corporation. And there are three tax objectives: reduce the US tax through the US tax base through use of earnings stripping interest, royalties, and other deductible payments, to avoid US tax on past foreign earnings, and to avoid US tax on future foreign earnings. So I would favor an approach that addresses all three problems